Hi, this is Cora Stack again, Dr. Stack. I want to give you an update, listeners and viewers, an update from the Supreme Court. And I'm also going to talk about this point here because I've come across it before, this concept of thresholds. And, and people would say, you didn't meet the threshold. And then you go to, the person and said, well, what's the evidence? And it seems to be completely subjective. So I want to raise this issue as why constitutional threshold matters. I mean, it's like proofs. We don't have that in mathematics, you see, the concept of the threshold, but I think it's something I have to raise here as a matter of concern. So hello everyone, and thank you for joining me. I want to begin with some positive and constructive news from the Supreme Court before explaining an important constitutional issue that I believe now needs wider public understanding. The good news, where the case stands now. The Supreme Court has indicated that it wishes to adjourn my challenges, my proceedings, which consist of kind of 4 questions, pending its determination of a foundational constitutional question, namely the constitutionality of the presidential nomination process, which is my question 1. That question is already before the court. That was a challenge by Mr. Niall Byrne in another pending challenge, and the court is actively engaged with it. The decision to adjourn reflects the overlap and confirms something important. These are live, serious questions of public importance. They are not personal, political or abstract. They go to the structure of our democracy and how constitutional rights are made effective in practice. To assist the court, I have requested that my case be focused on 4 core constitutional questions with the presidential nomination process as the foundational issue. I'll return to those briefly at the end. Now, the 2 issues, 2 similar claims, 2 different constitutional routes, as I understand it. What I want to explain now is why 2 very similar constitutional claims are being treated differently and why that matters. The first claim, I understand, is primarily relying on Article 28, not solely, but primarily, as I understand it. The first case before the court, as I understand it, relies mainly on Article 28, but also on other articles, which concerns the functioning of government. The argument there, as I understand it, is that a block directive issued by Fine Gael leadership, which then led to cascading blocking directives by other parties, interfered with the constitutional process. The court is examining whether that interference reaches the required constitutional threshold. In other words, whether it's sufficiently serious, concrete and constitutionally significant to justify judicial intervention. That threshold question is now central to how the Supreme Court is approaching that case. My claim, a different, and I believe, now this is my belief, it's a stronger constitutional route. Being a mathematician, you see, I'd have looked at the different, it's different ways of getting to the proof, but we don't have this threshold, problematic issue with threshold. My own case, the same question, examines the same underlying democratic harm, but through a different constitutional route. Rather than relying mainly on Article 28 and perhaps some other cases, my case is grounded on Article 12, Article 12, the constitutional framework governing presidential nominations, Article 6 and 1, popular sovereignty and democratic legitimacy, and by implication, Article 34, access to justice and the proper administration of justice. A critical part of my argument is the way the issue was handled in the High Court, combined with strict time constraints, meant that full constitutional education could not occur before the process was spent. Now, it took me a long time to get to this understanding. This raises a fundamental question. If a constitutional right expires before it can be properly examined, has there been real access to justice at all? This is now my major concern, and I'm articulating it because of my mathematical background and proofs and theorems and this is the problem that I have a concern about, and I'm just raising it. The threshold problem and why this matters. This is where the concern arises. Thresholds are not mechanical rules. They are judicial judgments about seriousness, impact and constitutional significance. I believe, and I want to be transparent about that a claim grounded in Article 12's 1 and 6, and then subsequently Article 34, sets a stronger constitutional threshold than one relying primarily on Article 28 alone, or with Article 28 and 12. Now, this is just alleged, because it goes directly to democratic participation, constitutional equality, and the court's obligation to ensure effective, timely justice. Here is the risk I want people to understand. If the Supreme Court were to find that Article 12-based claim does not meet the threshold, there is a danger, unless this is clearly articulated, that could be taken to imply that my claim must also fail, even though it arises through a different constitutional route with a potentially stronger threshold basis. This is not a technical distinction. It is how constitutional harm is recognised and reviewed. So I was hoping, and people that I was talking to this, that the Supreme Court will deal with the two questions together and consider which have the best threshold in order to make a decision, so that the matter was dealt with in terms of the highest threshold, and that both were grounded, with the best of intentions. But I felt that Article 12 was the strongest one to go in with, and would have the least resistance from a threshold, somebody who wanted to bring down that threshold, for cautionary reasons or whatever else that's used sometimes to not to want to kind of upset the apple cart. This is why I believe it would have been more coherent to examine both routes together, not to collapse them into one, but to compare how thresholds operate across different constitutional provisions. So this is the point I'm making now, and I don't know that the Supreme Court listened to me at all, but if they're thinking they're dealing with a fool, they should think again. They should maybe have a second thought. Invitation to viewers, help test understanding. So let's put it out there to the viewers. Let's because I'm trying to democratize law. I want to invite those of you watching, especially students, engaged citizens, and careful readers of constitutions. I mean, I have very, very bright people watching me. I mean, they're the brightest of the bright, to do something constructive. Please watch my previous few videos. If you want to read my papers, they're all on academia.eu. And again, it's all very explained, very clear. And then try to explain in your own words. This is what I always say to students. What do you think the core constitution issues there? When people explain an issue back in their own language, it shows to me what is being understood, where confusion still exists, and helps everyone, including Millie, clarify what really matters. That kind of shared reflection is how constitutional understanding deepens. I want to finish by returning to the constructive direction the case is now taking. To assist the court, I have asked the proceedings to be focused on 4 core constitutional questions: whether the presidential nomination process is constitutionally sound. This is the previous presidential process. Whether a nomination process, whether the election process complies with the constitutional requirements of fairness, equality, and democratic legitimacy. And I say that is implied constitutionally from question 1. And 3, whether court rules and practices can delay constitutional education until rights are effectively spent, raising serious concerns under Article 34 and access to justice. Whether the current protective disclosures regime following the 2022 amendments is legally effective, constitutionally proportionate, and compliant with EU law and practice. The court's engagement with the foundational question confirms that these issues are real, serious, and of wider public importance. Progress in constitutional democracy is often incremental, but it matters deeply. These questions shape how democracy functions, not just in theory, but in everyday life. Thank you to everyone who continues to engage with this work, reflect critically, and support it. With careful adjudication and principled decision-making, we really can move towards a fairer and more constitutional, accountable future. But let me come back to my point. See, the Supreme Court wouldn't realise that I'm an editor, and an examiner for a long time. So I see, theorems and proofs, and I can tell which is a stronger proof or a better proof, or which is weak, or which, all of this is child's play to me. But I am concerned here that the two cases weren't taken together, and that the stronger threshold, whichever was decided, would be the one that would win out at the end of the day, in case there was a view that the weaker one would determine finality on a stronger one, without that one being judged on its threshold merits. So this is something I feel is a mistake by the Supreme Court, that they should have, and a lot of people said that most likely they would look at the two nomination questions together, because they were based on different constitutional articles. So as I understand it. So again, I haven't had, so the first case before the court relies, as I understand it, mainly on Article 28, not entirely, which concerns the functioning of government. The argument there is that a block directive issued by the Fine Gael leadership was then led to a cascading blocking effected by other parties, interfered with the constitutional process. The court is examining whether the interference reached, this is the point, the required constitutional threshold. In other words, whether it's sufficiently serious, concrete and constitutionally significant to justify. So you're having this threshold decision. That threshold question is now central to how the Supreme Court is approaching that case, where my claim is a different one, and I believe stronger constitutional, as I understand at the moment, but perhaps behind the scenes they're looking at both together. Perhaps behind the scenes, but we're not, I'm certainly not clear about this. My own case examines the same underlying democratic harm, but through a different constitutional. This is the way I looked at it. Rather than relying primarily on 28 or mainly going in on 28, I grounded it in Articles 12, the constitutional framework governing presidential elections, Articles 1 and 6, in particular sovereignty of the people and democratic legitimacy, and then subsequently on Article 24, access to justice and the proper administration of justice. A critical part of my argument is that the way the issue was handled in the High Court, combined with strict time constraints, meant that full constitutional education could not occur before the process was spent. And I've introduced the idea or the new concept of judicial accountability, constitutional continuity to try and give that a better conceptually a better way of looking at that. This raises a fundamental question: if a constitutional right expires before it may be properly examined, has there been real access to justice at all? So the threshold problem. Now, sorry, I have to raise this with the powers that be. Why this matters. This is where the concern arises. Thresholds are not mechanical rules. They are judicial judgments about seriousness, impact and constitutional significance. I believe, and I want to be transparent about this, that a claim grounded in Article 12.1, Articles 1 and 6 and subsequently Article 24 sets a stronger constitutional threshold than one relying primarily on 28 alone. But I have not access to that particular proof, if you like, because it goes directly to democratic participation, constitutional equality and the court's obligation to interfere to effective timely justice. Here is the risk I want people to understand. If the Supreme Court were to find that the Article 28 base claim does not meet the thresholds, there is a danger, unless this is clearly articulated, that it could be taken to imply that my claim must also fail, even though it arises through a different constitutional route with a potentially stronger threshold basis. This is not a technical distinction. It goes to how constitutional harm is recognised and reviewed. This is why I believe it would have been more coherent, and what a lot of people said, that what would happen was that both routes together, that they would be examined together by the same group, just that particular question, not to collapse them into one, but to compare how thresholds operate across different constitutional provisions. I mean, that's what I would have done as an examiner. I would have done it that way. I wouldn't have, I wouldn't, because I would have understood, the threshold element there, and I would have said this would be morally unquestionable. I mean, I wouldn't have done that. So it's we have to raise it as an issue now at the moment, and hopefully, perhaps behind the scenes, this is what's been done, but I have no evidence of this. So while I'm very happy that the case wasn't thrown out, I am disturbed by this, and I can see how this could easily tear down the whole case when the stronger one could be the one that was never adjudicated upon.